victim's family and friends. I appreciate those as well. Before I get into the sentence, I just want to point out that, of course, these events that led to Will Sheffy Jr.'s death were easily preventable. Ultimately, defendant and the co-defendant's actions were shocking and reprehensible. Unfortunately, no adult really stepped in to stop this outrageous behavior that continued throughout the day. Instead, the defendant and the co-defendants treated the streets of Painesville like it was some sort of video game, chasing William Sheffy throughout the day, beating on his car, driving recklessly, and ultimately engaging in conduct that pinned him in to prevent his escape and ultimately murdering him in cold blood. He was not the only victim that day, as indicated by the state. Brent Adams and Jeffrey Lee were in the car when they were shot at by the co-defendants. And two completely innocent people, Mr. Reynoso, Mr. Ramirez, were just going about their day when they were struck by gunfire by the defendant's co-defendants. As to Mr. Gaines, his actions helped create that situation with the bantering back and forth throughout the day with Mr. Sheffy. He could have simply ignored it, said he took the opportunity to arm himself that day with a gun, later used by his cousin, Xavier Jackson. Mr. claims he didn't want any of this to happen, but frankly, that lacks credibility with the court based on his conduct while at the corner of Rockwood and State Street, where he follows William James Sheffy, prevents a realistic chance of escape, and hands a firearm to the co-defendant, Xavier Jackson. As indicated by the court earlier, the defendant wanted to fight. Frankly, the court did not understand that throughout the day, why that would even be possible, and the fact that, frankly, the defendant is much larger than the victim, Mr. Sheffy. And I do agree with what the state said. I do think Avion Gaines does show remorse, but I'm not sure it's what happened to William. I think it's for the consequences he now faces. So with respect to the court, I've considered the record, the oral statements made. As it's indicated, I reviewed the victim impact statements, reviewed the pre-sentence report and investigation. I've considered my conference in chambers with counsel, the statements of the defendant, defendant's counsel, and the prosecutor, and the statements made today in court. I've also considered the overall purposes of felony sentencing, pursuant to Revised Code 29-29-11, which is to protect the public from future crime by this offender and others, to punish the offender, and to promote the effective rehabilitation of this offender using the minimum sanctions the court determines to accomplish those purposes without imposing an unnecessary burden on state or local government resources. And I've considered the need for incapacitation, deterrence, rehabilitation, along with that public burden on governmental resources. And I've considered the recommendation made today by the parties. I've reasonably calculated the sentence to achieve the overriding purposes of felony sentencing, to be commensurate with, not demeaning to, the seriousness of the offender's conduct, its impact on the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. Using my discretion to determine the most effective way to comply with the purposes and principles of felony sentencing, I have considered all the relevant factors, including the seriousness factors in B and C of Revised Code 29-29-12, and recidivism factors in D and E of Revised Code 29-29-12. With respect to the seriousness factors in 29-29-12, factors being more serious than conduct normally constituting the offense, as outlined, the victims of the offense did suffer serious physical, psychological, or economic harm as a result of the offense. Of course, Mr. Sheffy lost his life. Mr. Lee had clear psychological trauma as a result of the incident. Mr. Reynoso, or Mr. Ramirez, who also testified, also suffered serious psychological or physical harm. With respect to recidivism factors, the only factors that would weigh in this particular case would be in favor of the defendant being no prior juvenile adjudications or no prior criminal convictions. Of course, the court will find the prison is consistent with the purposes and principles of felony sentencing. The defendant is not amenable to available community control sanctions. The defendant shall serve first a mandatory prison term of 1 year on the firearm specifications in Count 2 and Count 12. Those are each 1 year firearm specifications. Those must be served prior to and consecutive to any of the other counts. With respect to Count 2, the court further determines the defendant shall be imposed for a term of 30 years to life as to Count 2. The defendant is also to serve indefinite prison terms of the minimum of 8 years on Counts 5, 6, 7, and 8. And those would be a minimum of 8, a maximum of 12. Count 10, court sentences the defendant to 11 to 16 and a half years. Those are the kidnapping charges. As well as Count 12 and 14 are also 11 to 16 and a half years. So Counts 5, 6, and 10 are to be concurrent. The most serious of those the court finds is going to be count 12. Counts 2, 7, 8, 12, and 14 are consecutive. So the total goes as follows. The total is 30 to life on count 2, 8 years on counts 7 and 5, 6, 7, and 8, and 11 to 16 and a half years on count 12 and 14, plus the 2 firearm specifications. So the total prison term is 70 to 75 and a half years to life in prison. That prison term will be served at the Lorraine Correctional Institution with 356 days of credit for time already served. With respect to being more than the minimum, prison is needed to protect the public from future crime, and the minimum sentence would demean the seriousness of the offender's conduct. With respect to consecutive service, it is necessary to protect the public from future crime or to punish the offender is not disproportionate to the seriousness of the offender's conduct and the danger the offender poses to the public, as well as under 2929-14 C4B, at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the offender's conduct, as well as the offender has committed the worst forms of the offense, and the offender poses the greatest likelihood of recidivism, making maximum sentence appropriate. With respect to financial sanctions, in accordance with 2929-18, the court's not going to impose a fine, but the court is ordering the defendant to pay the cost of prosecution. Because some of the sentences do not include the life tail, post-release control is mandatory for the court to state. Post-release control is part of the sentence for at least the kidnapping, felonious assault charges. You'll be on a period of post-release control for a minimum of 2 years up to 5 years as determined by the adult parole authority. Now, if you were placed on post-release control, violating the conditions of your post-release control, the adult parole authority is allowed to impose more restrictive post-release control sanctions, or they can return you to prison for up to 9 months for each violation, up to a maximum of half of your stated prison term. If your violation of post-release control is a new felony, you may be prosecuted for that new felony, and the court which you are being prosecuted for the new felony may impose an additional consecutive prison sentence for a post-release control violation. Maximum prison term for the post-release control violation shall be the greater of 12 months, or the period of post-release control for the earlier felony minus any time you've spent under post-release control for that earlier felony. As some of these are also Reagan-Tokes case, Reagan-Tokes charges, I have to give the following advisements. Number 1, there's a rebuttable presumption that you shall be released from the service of the sentence at the expiration of their minimum term or presumptive earned early release date, whichever is earlier. Number 2, the Department of Corrections is allowed to rebut that presumption. If at a hearing they hold the Department of Rehabilitation and Corrections to make specified determinations regarding your conduct while you're confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. If described at these hearings, the Department of Rehabilitation and Corrections makes these specified determinations and rebuts that presumption, they may maintain your incarceration after the expiration of the minimum term or after the presumptive earned early release date for the length of time the Department of Rehabilitation determines to be reasonable. The Department may make specified determinations and maintain the offender's incarceration more than one time. If the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. I'm now going to read you your appellate rights, Mr. Gaines. Number 1, you have the right to appeal this matter within 30 days after filing the court's sentencing entry. Number 2, if you're unable to pay for the cost of transcripts, the record, and all relevant documents required for the appeal, those will be provided at no cost to you. Number 3, if you're unable to pay for an appeal, you're entitled to have a notice of appeal filed without payment of a filing fee. Anything else from the court from this? I'll start with the defense. I understand you wish to have the court, you wish to withdraw and have the court appoint appellate counsel, is that correct?
That is correct, Your Honor. My client is 19 years old. He was just sentenced to 70 to 75 and a half years to life in prison. The Ohio Public Defender Commission does list incarceration at the Ohio Department of Rehabilitation and Corrections as a presumptive indigency. I do understand that I was retained. However, there is case law that indicates that having retained counsel does not preclude you from becoming declared indigent. Your Honor, I do think because of the length of the trial and just the sheer volume of the evidence, he would be best served with me not being his lawyer moving forward. And so I would ask that you declare him indigent. assign counsel, remove me as counsel at this juncture, and allow Mr. Gaines to have transcripts prepared at state's expense. Thank you.
Thank you. Anything else from the state?
Just a point of clarification, Your Honor, and I apologize if the court said this. My understanding is the court did impose an aggregate minimum of 70 to 75.5 years to a maximum of life in prison. You had indicated the potential indefinite terms on all of the F1s and F2s. I missed it if the court designated a most serious qualifying offense. And the way that I understood the court sentence was that you wanted that indefinite term served just with respect to the most serious qualifying offense of the Reagan-Tokes
Yeah, I think I
counts.
said count 12.
Count 12,
I
okay.
designated as the most serious of the Reagan-Tokes offenses.
Thank you, Your Honor,
Thank
sorry
you.
if I missed that.
Thank you. And with respect to Ms. Corrigan, I'll get an order out to your motion to withdraw, okay?
Thank you, Your Honor.
Anything else for the court at this time? No?
Nothing from the
Okay.
state, Your Honor.
All right, we're adjourned.
All right.